Good afternoon. Thank you all so much for joining us. I don't know about where you live, but here in Sacramento, it went from miserably hot to fall overnight, and now it's cold. Outside of the weather change here in Sacramento, our other big change at Bradford and Barthel is our new website. Have you had a chance to look at it? I'm going to put a poll up on your screen here that you should see now. While you're answering that poll, which is, have you checked out our new website? I want to tell you a little bit about it. I am absolutely 100% biased about our new website, but I do admit that it was more user-friendly and it is much prettier than our last website. You will find some new areas on our website, like our diversity and inclusion page, and then you will also find some of the old pages that are revised and updated. When you have a moment, I recommend you check out the website if you haven't. I'd start by viewing our new attorney pages with brand new pictures and updated profiles, our newly revised blog page, our rating department, and finally, I recommend that you check out our previously recorded webinars. You can view those for CE credits. We have 66 of them now, if my math is correct. I am really bad at math, but I did count them today, and we have 66 videos that you can watch if you need those CE credits. So I'm going to go ahead and close that poll. And it looks like 33% of you said that that you have seen it. So the rest of you, go ahead and take a look at bradfordbarthel.com. You will not be disappointed. I think that you're in for a real treat today with Ryan Alves and JP Torres. They're going to be discussing factual denials. But first, we have a few B&B attorneys who would like to say hello to you all. Randall, would you like to get us started?
Yes, good morning, everybody. My name is Randall Stoddard, and I'm at the Concord office, and we primarily service the boards in Oakland and San Francisco. I've been with Bradford and Barthel almost 8 years, and I'd like to thank you all for attending the webinar this morning. If you ever need anything, my phone is always on, and I'm always readily available by email, so please don't hesitate to contact me with any questions of any kind. And you know, I like to hike around here and enjoy the open space, and try to get skiing if it ever snows again in California, and follow the local sports teams. And glad to be here. You guys all have a great day.
Thanks, Randall.
Hi, Joseph Vacherbeck. I'm at the San Diego Bradford Barthel office. I've been here for quite a while, and I've worked frequently on some of our high loss issues, but I also provide some services, including pro per settlements. It's been a real linchpin of our office to try and help out adjusters get some of the more difficult pro pers finalized in their STIPs and awards. So, you know, I want everybody to know that's available. And you know, without further ado, whoever's next.
It's me. Hey, everybody. I'm Bill Bartels, and I'm a partner with the firm, and I'm from the Anaheim office, although right now I'm in my home. I always dress like this at home just in case something happens. You always want to be ready as an attorney. In Anaheim, we handle the Long Beach, Anaheim, and Santa Ana boards. I've been with the firm now. I'm in my 10th year, and it's a great place to work. Good people, really smart people. As far as a personal thing, other than looking super washed out because of the light, I'm going to see the Rolling Stones tonight, so I'm kind of pumped on the Mick Jagger thing. So that'll be fun. And I appreciate working with all of you and know many of you, and look forward to talking to you sometime soon. But now I'm going to introduce you to our fearless leader and our master of all jokes and masks, Mr. Don Barthel.
Hey everybody, here's the new mask. You got to get a new mask. It's straight hot off the presses of Bradford Barthel mask, double thickness, adjustable. Let Tammy know if you'd like one, and it is yours. I'd like to say they're comfortable as well, but I don't want to lie to you, even if I am an attorney. I'm a founder of Bradford and Barthel and of the B&B AMA analysis and rating services, and I hope everybody knows we're statewide and have about 100 attorneys representing TPAs, employers, and insurance companies throughout the state all the time. I want to thank you all for joining us today. On factual denials, we've got around 700 plus people signed up for this. So obviously it's a great interest to the community. As far as the files that you have us represent you on, we really appreciate it. We consider it an honor, and I want to thank you because we don't say thank you enough for that kind of thing. Now, there was mention of bad jokes, and I have my reputation in that regard continues. Here it is. So a guy's sitting there reading the newspaper when suddenly his wife sneaks up from behind and smacks him over the head with a frying pan. What was that for? He asked. Well, I moved your suit, and out of the pocket came a note, and it said Mary Sue on it. Who's Mary Sue? Oh, for crying out loud. Remember when I went to horse races the other week? Mary Sue was the horse I was supposed to bet on. She walks away, unimpressed. The following week, she walks up from behind him again and smashes him again on the head with the same frying pan. He says, hey, wait a minute. What's that all about? Your horse just called. Told you it wasn't good. You get what you pay for. Anyway, I want to offer several things above and beyond the incredible mask. And again, contact Tammy for that if you'd like it. The blog, she mentioned the blog. Over 100 articles currently on our website, which I hate, by the way, because on the website picture, I've gotten 25 years older, fatter, grayer, and more stressed out. Definitely want to sign up for the blog, which comes out every week on the latest updates, regulations, codes, executive orders, case law. It's a great read. In fact, it's so good that WorkComp Central almost weekly picks it up and publishes it themselves. Tammy mentioned the webinars, that we have a lot of. You can get your continuation credit from the ones that are pre-recorded as well, not just this one. And we have a couple more coming up this year. On November 10th, we're going to be doing a case law update. And on December 2nd, we've got a legislative and regulatory update. And man, there's been a lot of changes. So definitely check that out. Finally, the COVID task force. As soon as COVID started hitting, we put a task force together that write articles, give presentations, handle hundreds of, well over 100 COVID-related cases, from soup to nuts, basic denials to multiple death cases. So if you have any questions regarding your COVID case, and I know that's all we have is questions on COVID these days, please email them at COVID, COVID, at bradfordbarthel.com. And of course, if you have a referral on a case that you'd like us to assist on that score, be happy to do it. Please contact us that way as well, or phone call, whatever. I think you're in a real treat with Ryan and JP today. To give you some idea how much we treasure and respect them, Ryan is the managing partner of our Sacramento office, and JP helps out on the management of the San Jose office. Both have many years of experience in our wonderful industry. And Ryan actually even specialized in workers' compensation before becoming a defense attorney, because he worked for 7 years as a senior case manager at Liberty. So as a result, he knows, he understands, and he appreciates the pressures and needs that a client who is sitting at the claims desk is going through. So he can definitely feel your pain, and both of them are more than happy to answer any of your questions, as am I, of course. So enough pain coming out of my mouth. You all have enjoy, and take it away, gentlemen.
I was saying thank you, Don. Again, my name is JP Torres. I'm the assistant managing attorney here at San Jose. Our primary venues are Salinas and San Jose, but really any of the Bay Area boards are great. I've been with the firm a few years now. Something personal about me, I love coffee. That's take it or leave it, but I'm definitely needing some of that for this morning. I see some very familiar names. I saw Abby, Paula, Latia, just a few of the many names out there today. Hello. Sorry you see my face now. Hope you guys enjoy this presentation, and I'll pass it off to Ryan.
Thanks, JP. Good morning, everybody, and thank you so much for attending. My name is Ryan Alves. I am the managing attorney and a partner with the firm. I'm based here in Sacramento. We cover primarily the Sacramento and then the Stockton boards. I've been with the firm for 10 years, and I think Don stole my entire introduction. I was an adjuster for 7 years before that. And so, yeah, I've been in your desk, I know how difficult it can be to get away to attend something like this, so I really appreciate it. I see some names in there that I've worked with over the last 17 years. If it's really been that long, I think I saw Bob Koftovic from Liberty. I saw Jasa and Glendon from my favorite Midwestern cornfield. So thanks, everybody. And because Don stole my introduction, I am going to try to one-up his joke, but only because he came up at dinner last night. I was talking to my sons and I said, you know, we've got a presentation tomorrow morning, and Don always tells a really bad joke. And my youngest, who just turned 5, said, well, Daddy, why don't you tell a good joke? And I said, okay, buddy, that sounds great. He said, you can tell my joke. And so I made a promise that I would tell it, and it goes like this. Why did the child cross the playground? To get to the other slide. And apparently that slays in TK. Thank you for indulging me and allowing me to keep a promise to my 5-year-old. He'll be very happy when I get home and tell him. All right, so we're doing factual denials. Here's what we're going to talk about. We're going to talk about the burdens and AOE COE. We're going to talk about where we're going to get our information to make that determination regarding AOE COE, some of the tools we have at our disposal, additional tools that we can use if we have to enforce discovery. We're going to learn that discovery is supposed to be informal and everybody's supposed to play nice, but of course that doesn't always happen. And we're going to talk about some additional considerations that will come into play when you are trying to make a determination as to whether you want to accept or deny. But first, we're going to rewind a little bit just to take a quick look at the basic structure of workers' comp in California, because it's a little bit different. Most of the laws that we're familiar with actually date back to English common law before anything was written down. Most of that law came over here, was codified over time. Workers' compensation is not that. Workers' compensation is purely a statutory creation. And in the case of California, it's actually in our Constitution. So I was trying to find out how many other states, if any, had workers' compensation as part of their constitution. And I wasn't able to find that. If we were doing this in person, I would ask you how many other states have state funds, because I was surprised by that answer. It's actually only 12. And of course, among those 12, California, I think, is probably as large as the rest of them combined. So as long as we're talking about statutory sources of law, let's see what those sources are. Everybody knows this one. This is our labor code. This is our blue book. They update it from time to time when they feel like it. Also in that book in the back, we've got our regulations. These are what the WCAB puts together once the labor code is issued or enacted by the legislature. It fills in a lot of the gaps and kind of gives us some working rules, because wouldn't you know it, the labor code can be a little vague and it can leave some things out. So we've got some WCAB rules that mostly you don't have to worry about. We've got the policy and procedure manual, same thing. And then we've got local board rules, which technically aren't supposed to exist, but of course things vary by board and things vary by judge. And there's been an explosion of local rules lately since we started going back to doing trials and expedited hearings in person. I had one judge say, you will sit in your car until I text you. And that is it. And that's the end of the story. So that I think is a decent example of a local board rule. JP, do you have any fun ones over at your boards?
So far, no. However, I did hear in some of the SoCal boards that for all these in-person ones, the first day of trial is always going to be virtual, no request needed. I mean, when you think about it, that makes sense. I mean, how many trials do we have that they're on calendar, but we're able to settle eve of trial or morning of trial? So that hasn't made its way up here yet. So for us, we are definitely having to request virtual appearances for all expedited and regular trials.
Okay, cool, thanks. Yeah, I don't think I have found two judges that are handling the in-person trials and expedited the same way. So we're all just kind of figuring this out as we go. I think we mentioned at the top, I see we've got some notes in the question window. Feel free to throw anything in there. We will do our best to get to those. If we can't today and you've got a really good one, just send me an email, give me a call. And that's true actually for anything, especially as a former adjuster. I'm always happy to help with random questions as they come up, but I digress. Back to the slides, we've got burdens of proof. So the applicant has the initial burden of proof, and in doing this in person, I would do a quick hand poll, ask everybody, especially if we had a newer group, who has the burden here? Does the injured worker have to prove injury, or do we have to prove that they weren't injured? And we'd have upwards of half of the people saying that we had to prove that it didn't happen, because honestly, that's how it feels, and that's how it seems a lot of the time, because as we will discuss, the applicant's burden to prove their injury doesn't mean that we can just sit on our hands and wait for them to produce evidence of their injury. We do have an affirmative burden to investigate in good faith once the injury is reported. So the thing that is squarely on our shoulders, and severely so, is the burden to prove apportionment. If we have not buttoned that down by the time we get to trial, many, if not most, of our judges will be happy to throw it out because they know that means there's more money for the injured worker. So that's one thing that we really want to scrutinize, especially if we have a decent amount of apportionment. If we've got 30%, 40%, 50% more, we want to make sure that the doctor has articulated that opinion to a reasonable degree of medical certainty, and provided some explanation as to how they arrived at that level of impairment. Because that is one that if we try to cut any corners, or maybe just hope for the best, it doesn't always end up working out for us. So, all right. So this is our AOE-COE language here that I think most of you are familiar with. It's in here just because I wanted to highlight this part in the middle here, that this is without regard to negligence. We always hear that it's a no-fault system. And this is where it comes from. So this gets to be something that we end up discussing a lot with smaller employers, especially if they don't have a lot of claim history or claim exposure. They might not understand that it doesn't matter if the employee did something wrong, that the injury will still be compensable. All right, we've got our AOEC. Okay, let's just do both. We've got arising out of and in the course of, and we hear this all the time. And here's what the actual definitions are, and they end up being very intertwined, such that it's sort of difficult for me to come up with fact patterns that only involve one or the other. So if you have if you don't have arising out of employment, if you just have in the course of employment, this might be a job abandonment sort of issue, or this might be, I get fed up with JP for getting more take nothings than me, so I go punch him in the face. We'll set the initial aggressor stuff aside, but that's something that arises out of our employment, but it's not really part of my job. Or I'm sorry, the other way around. It's in the course of our employment. We're at work. It's not in my job description to punch him in the face. The other way around would be is if it were in the course of employment, but didn't arise out of employment. You might have a situation where you're hanging out after hours with your office. That kind of arises out of your employment, but it's not in the course of employment. Again, a little bit difficult to parse those out. So, okay, so we hear substantial evidence a lot. What is it? My short answer is whatever the heck the judge decides it is. As it turns out, that's the actual definition too. It's the determination made by the judge as the trier of fact. They are the trier of fact. They determine what is a fact in your case. That determination has to be based on substantial evidence, and that evidence is what we give them. The judge can only base the decision on what we provide to them. So if we give them garbage, you're gonna get a false
comparison.
It can't be based on an incorrect legal theory, speculation, conjecture, or guess. So this is the same sort of thing we're looking at when we review a medical report, right? If the doctor or the judge says, I think this applicant lost 50% of the use of a body part just because, not substantial evidence. If the judge says this injured worker didn't report their injury within 48 hours, therefore it's not industrial, that's an erroneous legal theory. We see this kind of a lot in psych injuries because we have 3208 and all these additional burdens and barriers, and people mix those up quite a lot. So the punchline for our purposes is you want to be really thorough. You want to document everything. The theme of this entire presentation is document, document, document. So let's talk about our different types of evidence that we might be looking at when we're assessing AOE, COE, and whether we might want to deny a case. We've got medical evidence, right? So you're looking at, you have the CT or specific, is there medical evidence to link the work injury to the employment? So the thing that really got hammered into my head as an adjuster was make the doctor articulate a causal link between the mechanism of injury and the objective findings. And I find myself asking that question of our doctors, whether they're treaters or med legal doctors, almost every day. That link has to be articulated in affirmative terms. I have very little patience for doctors who say, well, there's no other explanation for how this could have happened, right? They have to say this objective finding was caused by this particular mechanism of injury. So when we're investigating claims, it's important to pin down the applicant as much as you can on what exactly happened. I used to, and I still do, ask them to imagine that they're moving in slow motion, and we'll take it fraction of second by fraction of second. Okay, you say you slipped. Okay, what did your foot first touch? Did it move forward or to the side? And we go through the whole thing. And then that gives you a framework for your questions for the doctor. Doctor, here's this breakdown of the mechanism of injury as reported by the applicant. Does this make sense? Could these objective findings have been caused by this injury? So that's the medical side. And honestly, then we're probably dealing with that more often than not. But you might also have a factual basis to deny the case. I've talked to employers who have just told me that this is impossible. This literally could not have happened. The applicant said this entire tower of pallets fell on them, which was a case I had a few years ago. And the employer said, no, that just couldn't have happened because of the braces and the supports, and this is why. And so that might be a factual basis. You might not be disputing the medical side of it at all. The doctor could say, hey, this guy's hurt, and here's how he told me it happened. And you say, cool, I don't care, because that could not have happened at work. The more common case is just exaggeration. For a long time, my wife was a fraud investigator, and so many of those cases were not picked up by law enforcement because it was just an exaggeration of an actual injury. And then the injured worker would just say, well, yeah, sure, you caught me on film doing X, Y, or Z, but it hurt really bad and I couldn't get out of bed the next day. So, all right, we've talked about some of the considerations that we're looking at. Well, where do we get our information? First stop is always going to be from the applicant. I think I had a day, maybe two, to call the applicant, the employer, and the doctor's office when I was doing my claims investigations. So we've got applicant, we've got employer. Witnesses and coworkers are great. You usually aren't talking to them on day one, but if you can, I would recommend talking to them as quickly as I can. Medical providers, and then if the case warrants it, maybe you are also talking to an investigator. And especially if you delay a case or deny it, you will be talking to EDD. And actually, you can get some really great information from EDD. I am litigating a lien right now, and I took a pretty close look at their form, and there's a checkbox where the doctor has to indicate whether there was a specific injury or incident. And my claim was a specific, and the doctor checked no. So I drew a circle around that and highlighted it, and then highlighted it again, and scanned it in color and sent it to EDD and said, well, what gives your own documents say that this wasn't a specific injury? And had the case not already been settled, I would have been waving that around applicant's counsel and the treating physician and the QME as well. So you can sometimes find surprising stuff from EDD as frustrating as they can be in most every other circumstance. So let's take each one of these in turn. What do we want from the applicant? Aside from just to go away, we want the claim form. This is going to start our timeframes for our investigation. This is going to start the case. We want the application if we get that far. We really want their statement. If you get it early, the guard's probably not up. They haven't been retained counsel. They haven't been advised by counsel. They haven't talked to their aunt who got $1 million on her claim in 1992. You're going to get your cleanest account of the injury right up front. So it's a very important piece here. Deposition will usually come later, and the statement is actually one of the most useful tools for the deposition as well. If I'm deposing somebody, I want a good statement because of course I'm looking to impeach them or pin them down under oath to
synonym for host.
Okay. We also want the applicant's version of their job duties. This is something that I think is underappreciated because this is what they're going to be telling the doctor. This is something they're going to be telling the QME. We want to know what their story is. And then we're going to want to compare that to what we get from our employer. And we want to identify any gaps in those accounts and reconcile them. You don't want the first notice that your applicant has a wildly divergent idea of what their job was to be when you get the QME report. So this isn't necessarily directly from the applicant, not usually anyway. You want to know about prior claims. This is typically going to come from an ISO, but you do want to ask. There are claims that won't show up on an ISO that sometimes you can get the applicant to admit to. All right. From our employer personnel file, for all claims, especially for a site case though, especially if you're looking for a good faith personnel action defense, you definitely want the personnel file. The wage statement is something that is critical, and even as an adjuster, I was shocked at how much difficulty I would have getting a wage statement. And then later, you're making corrections. You've got underpayments, you've got overpayments. You want to price your case accurately for early settlement. You want to get that as quickly as you can. Here's our job description. Again, you want to make sure that that matches what the applicant is telling you, so you can get ahead of any discrepancies. Employer witnesses can be really critical and can make or break your case. And depending on your employer, they might be a perishable resource. Depending on your type of job, seasonal employment, things like that, you may want to give consideration to actually deposing them if it's a litigated case, especially. I did that in one case where I lined up 3 witnesses in our conference room, and all 3 witnesses testified that the applicant had told them he was going to fake their injury. Had then told them that he faked the injury, and then later told them that it was a real hassle maintaining a fake injury. And so we finished that, and I had a brief side conversation with applicant's counsel, and that case was done. But we did that, one, to leverage a quick closure and withdrawal of the claim, but also in this particular case, those employer witnesses weren't going to be available for more than another month or 2. They were working on a specific job, and they were going to be moving on to something else. So. All right, you're going to want your employer's first report. This is going to have all kinds of great information on there. The first thing I look at is the date of knowledge. I want to make sure that we have documented our date of knowledge. That's going to start all of our timeframes that we'll talk about in a bit. And we want to make sure that matches what the applicant is telling us. We can also verify earnings on that and get a good estimate if we don't have the wage statement. Every once in a while, you've got somebody that has already gone back to work, so that's nice. And then I'm frequently surprised at how often 2 years later I'm going back to this form just to get the applicant's occupation. All right, from medical providers, we want the doctor's first report and the doctor's first report and the doctor's first report. I use that report over the entire life of the claim. Like the initial statement that the applicant provides to you, the doctor's first report is going to be the cleanest, most accurate, contemporaneous account of the injury. And we've all seen cases that develop, I think is the euphemism, over time, right? You've got the shoulder, then you've got the other shoulder, and then you've got the neck, or you've got an ankle and then a knee and then a hip and then the other knee, and then of course the back hurts because your stride's deranged. Or you just down the line, you get a QME report and the the injury is completely different, right? Or it's much more severe. So I've got a case where the mechanism of injury is literally somebody bumped into the applicant, bumped into her back. And, I injure myself more severely than that most mornings. And my two sons definitely do more damage to each other than that on any given day. And so it's this really innocuous thing. And then 6 months later, of course, she fell and landed on a piece of metal, and it's a whole different thing. So definitely go back to that and document it and carry that through your file documentation. All right, every once in a while you might need an investigator, and honestly, maybe we should use them more often. One thing that I think is really underutilized is a locus investigation. Sometimes it's really useful to have a sense of where the injury happened, and that's something that I didn't have very often as an adjuster. I don't have very often now, but depending on the type of injury, it can be really, really important. You can communicate to your doctor or your judge or applicant's counsel, exactly what happened to the applicant, what they fell on, what they fell from. And so that's something I think that is a resource that is underutilized. You're going to be able to get good witness statements. The investigators typically do a very good job with witness statements. The social media investigation is another one that is very easy for us to do at our desks, but I do not recommend that we actually do that work. I don't recommend that the adjuster does it. I don't recommend that counsel does it, because you need the witness to testify later on. That page is going to get changed at some point. You're going to disclose this information, and all of a sudden all those social media pages are going to disappear, or they're going to be made private. But if you have an investigator that you can put on the stand that says, no, I'm the one that looked this up on this date, this time, and I saw this picture, and it had this date on it, that's the way you're going to get that into evidence. If I just show up at trial and I say, well, my adjuster found this, or I found this, then we are subject to cross-examination about that, and it's probably not going to get it. You might be able to get some information about prior and concurrent employment. This would be based on conversations with the employer, coworkers, friends, family, prior claims and accidents. Again, we've got witnesses is so important. We've got it on there twice. And then you've also got sub rosa. And the same thing, you want somebody to testify to lay a foundation for that sub rosa. Technically there is an articulable suspicion standard for sub rosa. It ends up being a pretty low bar. I've never had to argue it as an adjuster or litigate it as an attorney, but technically we should have some documentation in our file as to why we suspect that our injured worker might not be being completely honest with us. All right, EDD information. Like I said with my anecdote earlier, there can be some really good information in here. They're frequently going to provide different information to EDD than they will provide to us. They're frequently seeing a different doctor for substantiation of the EDD payments than they are seeing through us. So we can go get those records. If the rate is different, if the EDD is paying at a significantly higher rate, that's a huge red flag that the applicant has another job that you need to investigate further. There might be a mismatch in the body parts, and you might be able to find out about prior claims, although EDD tends to be a little tight-lipped when it comes to claims and issues that aren't directly related to yours. And then the reason you want to try to get this information in the context of a delay or a denial is you want to know what they paid, so that if and when you ever pay, you don't have a duplication of benefits. I'm sure most of you have litigated the duplication of benefit issue, and it really just comes down to notice. So if EDD sent us something and we didn't investigate, and then at some point later we go and just pay, we will typically end up paying those benefits twice. All right, I think everybody's probably familiar with the 90-day presumption. If you don't deny the claim within 90 days, it is presumed compensable, unless you can find some information that was not available within the 90 days. Now, there is an exception that actually I didn't even know about until I was looking at this presentation. Good faith personnel actions exist outside of this. There was a long decision where the board held that there is supposed to be a higher bar for psych cases per the intent of the legislature. So we're going to let that information come in later. Now, something that I probably didn't know or maybe forgot for most of my time as an adjuster was that you don't automatically have the 90 days. If you make a determination on day 10, you have 14 days from that date to issue your denial. And that's not usually going to be caught by applicant's counsel. I have literally never been to court on that issue. JP, have you ever litigated that one?
No, I would say no, because not at the time of. I would say, and I was going to touch on it later, if the applicant suspects there's something going on and they subpoena then the investigation you've conducted, I could see that coming up then. But initially, I think they just assume that you're going to take the full 90 days to figure out what happened. I personally have never seen that happen.
And I think the judges make that assumption too. The question the judges will ask us is, well, did you deny your case within 90 days? But if you have documentation in your file that says that you have a determination and you're outside the 14 days for the denial, and that file gets pulled on an audit, then you'll probably get dinged for that. So, all right, let's talk a little bit about claim professional roles. So this is what I alluded to earlier when we were talking about the burden of proof, where it seems sometimes like it's actually our burden to prove that the applicant wasn't injured. And that's because we have an affirmative burden under Regulation 10-109, which says that we can't just sit on our hands and wait for the applicant to produce evidence of an injury. We have to, in good faith, investigate it. We can't just document our file with facts that support a denial. We have to document all the facts that we learn, again, in good faith. And that's where the obligation comes for us at the beginning of the case. Now, while you're doing that, if you are taking up to the 90 days, if your case is on delay, you are paying for medical treatment. And it's still up to $10,000, although, JP, do you remember what they were trying to bump it up to? They were trying to reduce, or there was a proposal, there was some proposed labor code that was going to reduce the investigation duration and then increase the obligation to pay medical benefits, but I don't remember off the top of my head what those numbers were.
I don't remember if it actually even went through or not, but there was, you're absolutely right, a suggestion or recommendation to drop certain injuries from a 90-day to a 45-day investigation period. Interestingly enough, that came around the same time where that COVID reduced investigation time. So I believe that they were like, well, if you can do it for COVID, why not some of these other ones too? I don't know if that actually went through or not. There was also, I believe they were trying to double the medical payments in that pre-investigation period to, I want to say 20,000, but I don't have the text right in front of me.
I think it was double the medical in half the time. Or pretty close to that. So, but that didn't go through. It may come back around though. It seemed to be pretty fully formed. All right, couple pointers here, and it's kind of getting back to some of our prior points. Our employer communication is going to be vital. They're going to tell us if the injury could have happened or not, or if the injured worker was even there that day. I've got a trial in a couple weeks where a coworker is testifying that the applicant wasn't even there on that day. So that's what you're going to get from our initial employer contact. And again, and if you have an investigator do some of this work, they are going to be able to testify. And then also we can protect that information as attorney work product. We might have to disclose it at some point, but we can certainly hold on to it a lot longer than we would have been otherwise able to. All right, I think JP, you're going to pick up and run with denial of the injury.
Yes. So for this section, we do want to note that normally when we deny the injury, there's two main reasons for that. And that's either because A, the injury, we agree that the injury is there, that there is an injury, but it was not work-related, it actually was already pre-existing that was there. Or perhaps that, okay, yes, the injury did happen, but it didn't happen at work. So those are the two type of things you're going to see. For example, pre-existing condition, we always look at hypertension, heart condition, pre-existing back condition. Those are usually easy enough to find out once you do a little bit of discovery. Again, that might be after the 90 days, but at least we'll get that. And then also the injury happened off-site, away from work, and the applicant broke his leg, alleging it happened at work, but a little bit later we find out it actually happened the day before or something, right? So that kind of thing is one thing we want to be aware of. So going to the next slide, we look at our bases for denial. Ryan touched on that 90-day rule, which is very important, but we also want to be reticent that 90-day rule starts, the time clock for that starts when the claim form is filed. So one is a hard and fast rule, which is the claim form being filed, but then when the employer gives that claim form to the employer, has to do with a knowledge, and that one, not necessarily a legal penalty, but definitely an administrative penalty can attach if the employer doesn't provide that claim form within time of knowledge. But I do have to caution everyone that claim form, because that's when the 90-day starts, you have to be aware that the employer may have that claim form. The code 5401C actually says that the claim form can be personally delivered or mailed. So if the employer personally delivered that claim form, and this has happened before in cases that we've handled, the employer says, oh yeah, we got it, and Sally's secretary accidentally filed it in the wrong box, nobody knew about it, and lo and behold, there it was, 180 days later, then you're kind of going to be stuck with it. So then going forward to the next slide, subsequent denials. Now, after the 90-day investigation period, if we find out new information that we could not have discovered during that 90-day period, then, of course, we can do a subsequent denial. However, again, something to be aware of, that if you're going to do that, you should have those facts and evidence ready to go, because an accepted case that then is subsequently denied, that immediately brings up a tribal issue, and depending on how aggressive your applicant attorney is, they could immediately file a DOR, and you should be good to go for trial on that. And then going to the next slide, partial denial. So partial denial is sort of like a misnomer. I mean, in this case, the whole claim is actually accepted, and what we're just disputing here is either certain body parts or certain aspects of treatment. So with the partial denial, you don't actually need to worry about the whole AOE, COE situation. There's no presumption of the 90-day rule for the partial denial. Labor Code 4600 actually states that you cannot get a compensability panel based on a partial denial if the claim is accepted. So really, partial denials, we're talking about disputed nature and extent. And then going to the next slide, for the reasons for denial, really there's two basic types. There's our legal defenses, denials based on a legal issue such as no jurisdiction, no employment. These are what your lawyers will call your affirmative defenses. And of course, the other one would be medical evidence. If the doctor say, well, no, this back injury is actually not a CT, it's actually just due to aging. I had a QME deposition just yesterday. I was like, well, doc, isn't this a CT? Nope, just aging. So then no injury, right? So, and then we go forward to your duty to investigate. Ryan touched on this earlier, but it's very important that we be aware that just because the employee doesn't give you supporting evidence or documentation of the injury, that by itself is not grounds to deny. The defense claims professionals, they have a duty to conduct a reasonable and timely investigation of that claim. And going on to slide 27, we see that it has to be an objective investigation. So good or bad, we do need to find out what happened. And continue. And slide 28 here, it talks about in parentheses C that that duty to investigate continues if we find out new information after even that 90-day time has elapsed. We do have or even earlier, than that, we have a duty to continue investigating. And some examples of that could be that if it's a particularly serious injury or complicated injury, and the employer sending investigators to the factory, the site inspection, that kind of thing, and that is not completed until after the 90-day has passed, if it turns out you discovered new evidence that now will change materially your decision, you need to, we can't just sweep that under the rug. And then going on to slide 29, the claims administrator must document the claim file for investigatory acts undertaken. So what that means is that, in all probability, if there is a dispute on what steps were taken for that denial, these things can be discoverable. So it's very imperative that you document a good reason why. And then going on to the next slide, this is slide 30. Just be aware that when a case is denied, then normally the 40-60 presumption, the 40-60 panel becomes applicable. There is a typo on the slide, and Ryan will touch on this further down the road, but definitely if there is a denial of the case after the statutory time has elapsed, either side, in a represented case, either side can go ahead and pick that panel. And then slide 31, going on, again, the other labor codes for getting that panel, 4061 versus 4062. Once an objection is made, we can go ahead and request that panel. And once we have that panel, then the QME can opine on all issues, including AOE, COE, on an accepted case. I have one where the case is accepted, definitely accepted, but then after going to the med-legal, the QME goes, well, this is not an injury. Well, then clearly, even though it's an accepted case, AOE, COE was not at issue then, with the medicals changing later than it is now. So with that, I'm going to pass it back to Ryan.
All right. And as is usually the case on these things, when we're having this much fun, time does tend to fly. We'd like to leave a little bit of time to do some questions at the end. So we'll move through these at a bit of pace. This is my favorite slide title. Bad denials are bad. I think most of us are familiar with penalties. The thing you want to watch out for here is too many of them. You'll get hit by a pattern and practice audit penalty. But this is just outlines what's at stake if you don't document your file. It's not even necessarily that you did anything wrong. The outcome could be correct. The case should have been denied, but if you don't document thoroughly enough, you could still get hit with a penalty. So again, the title of this whole presentation probably should have been document, document, document. A quick note here, if the indemnity rate has gone up, the typical fact pattern would be the applicant was scheduled for a raise. You just pay him the higher rate for the entire claim. So here's where we get into the audit penalties. We've got $5,000 for each occurrence. Okay, that's a lot of money, but the real danger here is pattern of practice if you get hit with too many of them. And again, this is what you want to document your file with, right? You don't want, well, the employer doesn't like this applicant. You want, the employer said this couldn't have happened because of X, Y, and Z. Just pretty basic fact finding, but then once you find the facts, document your file as well as you can. Okay, so this is the slide that JP alluded to a moment ago. I have really good news. This is an old version of the slide. It's wrong. If you look in your labor codes, you will not find Reg 30D3, which did at one point hold that only an applicant was able to get a panel after denial. Thankfully, that's gone. In fact, there was an en banc decision that held that that was unconstitutional and that everybody should be free to request a panel. So apologies for that. Okay, so you've got your evidence. What do you do with it? Well, you scrutinize it, you look at it, you see if everything makes sense, right? Is the date of injury consistent? Were they actually working? Do we have any evidence to the contrary? The next one is my main one. Is the mechanism of injury consistent, right? Again, do the objective findings match the mechanism of injury? Explain it to me, doc, connect the dots. Is the drum that I'm constantly beating, and that was quite hammered into my head as a new adjuster. Long-term or short-term employee, this is more of a red flag sort of thing. If you've got someone who was hurt on their first day, maybe a little extra scrutiny is warranted. Good employee, bad employee, same kind of thing. Might lead you to scrutinize some of your other facts a little more closely, but it could have a direct effect if you have a psych case. That employee is more likely to have been written up recently. Physically demanding job, right? If I show up and my whole back is blown out and our insurance carrier says, well, this guy's an attorney, he just sits at his desk and drives every once in a while, right? Maybe the adjuster is going to scrutinize that. There seems to be a disconnect there between what I'm presenting with and what my job is. Employment before, during, and after. Yeah, you want to know is, did you have concurrent employment? I've got a case right now where the applicant twisted her ankle at my job, but then shattered it at her other job a week later. And so we're trying to parse that out. Well, what's ours? What's theirs? Where can we draw that line? Is it all theirs? And she just, maybe their claim got denied, so she's trying to get benefits through us. Chronology here is important. Is there a gap between when the injury was reported? Is it a year later? Is it a week later? Is there a delay in the beginning of treatment? That can be problematic for a whole bunch of reasons. Maybe the case is still compensable, but you have a real tough time investigating because you're asking the doctor those questions, right? Was this caused by the injury? Or are these objective findings caused by the mechanism of injury? And the doctor might have some trouble making that determination if it's been 6 months. Witnesses are, of course, useful. I've got my 3 witnesses who told me under oath that the applicant told them how difficult it was to maintain a fake injury. Prior pending surgeries. I mean, I fought a case for years. The guy hurt himself on the first day and needed emergency total knee replacement that day. Well, turns out that was his 5th knee replacement. And so we said, like, why is this ours? Barely anything happened. He was fixing a sprinkler, and we ended up getting hit with it. But it was certainly a red flag and something we spent a lot of time and effort investigating. Objective findings. This is part of the question about the mechanism of injury. I always ask, and I always recommend that claims asks our doctors to frame everything in terms of objective findings. Don't just tell me the knee is injured. What specifically in the knee is injured? I don't want the knee. I want a specific diagnosis that's supported by specific objective findings. And you'll get a lot of pushback from the doctors. They just want to tell you that the knee is hurt and that we need to pay for therapy and maybe we need to scope the knee. All right, so how are we going to get the evidence? It's supposed to be informal in comp. That's the main thing. In the labor code, there's a mandate that discovery is to be basically relaxed. And you're supposed to just be able to ask nicely for things. But that obviously doesn't always work. So we may need to escalate and start subpoenaing things. We may need to set depositions. And there's a note here about attorney fees. And this used to be a lot scarier. When I was an adjuster, if you were the one to file an application, you could be on the hook for hourly attorney fees over the life of the case. And obviously that was something we were very leery of, and that's not the case anymore. A few years back it changed so that if we file an application, we may be on the hook for hourly attorney fees, but only on that specific issue. So if you want to set the deposition of the applicant, you've got to go to court to get an order compelling. You might pay for the deposition fees like you normally would, and you may have to pay the attorney to go to court to argue about it, but you're not on the hook for the life of the entire case, which is nice. So if you do have to go through formal discovery, again, this is requiring that this stuff work pretty easily. Liberal pretrial discovery is the ideal. Our rules of discovery and evidence are somewhat relaxed compared to civil discovery. It doesn't always happen that way. So then we end up having to enforce discovery, right? So we want to show that we attempted to meet and confer. If I show up at the Sacramento or at the Stockton district office and I have not met and conferred on a motion to quash, I will be in a lot of trouble. So you do want to try to resolve it informally. If not, you can start filing petitions. And usually they'll back off and you can take the matter off calendar. So why did I have to file it to begin with? You know, I don't know. But back to the penalties real quick. You really don't want to issue a denial unless you've got the evidence to back it up. That could be bad faith. That could result in an increase in rates. Your claim gets more expensive in addition to the audit penalties. So some benefits to admitting the case. Again, this is assuming that you have done your good faith investigation. The benefits here are to admitting it right away and not waiting until the end of your 90 days just because you were busy, which, hey, I understand. But if you are going to accept the claim, if you are done with your investigation, do it sooner than later, right? You can, your medical control, your MPN snaps into place. You don't have a big EDD lien to deal with. Make sure you check with EDD first. Call them, email them. If you need help with that, let me know. We've got some secret numbers and email that we can try to help you with. UR is going to control the treatment, right? And they do a pretty good job of that overall. You know, the next couple points depends on the attorney, right? Maybe they're more cooperative. Maybe they're happy their client's getting benefits. Sure. Does that make them more willing to settle? Sure, sometimes. Does it make them more inclined to go with an AME? Maybe, but you know, if Don's on the phone, we're gonna have to mute him so he doesn't start telling us exactly why we should never use an AME, because we don't recommend it most of the time, more often than not. So if you have made your determination and you're going to get your denial out, again, same thing, probably better to do it sooner than later. Again, you do only have 14 days from the time you make the determination. You know, you're not worried about managing the treatment anymore. You may have to do some retro UR later, but for the time being, you're not going to have to. Yeah, probably more likely to go with a panel. I mean, we seldom recommend AMEs full stop, but certainly not in the case of a denied file, and you're not dealing with any immediate duplication issues with EDD. Same as always with EDD, though. If at any point you do pick up benefits, definitely check with them. And I think we might have made it just barely. Do we have any good questions? If not, please send those later. If you're like me, you will think of a lot of good questions this afternoon. That's my best questions are always about 4 to 6 hours after the ideal time to ask them. So send those at any time.
Thank you so much for spending an hour with us today. I hope you all enjoy the rest of your week and take care. Bye-bye.